Hello, my royal lovelies, and welcome back to the channel. Welcome to my home. Today, I want to talk about a story that has very much two different viewpoints, two different perceptions, two different narratives, and I just want to kind of get stuck into it. So I am, of course, talking about Prince Harry's legal action against associated newspapers, including the Daily Mail and the Mail Online. Rupert Murdoch's publications. So, obviously it's ongoing. I think there is going to be some kind of trial round about March, April time. We don't have the exact dates, but as you can remember from previous videos earlier in the year, Harry and a number of other celebrities, including Elton John, gave kind of evidence, testimonials. Everything went very public in the public domain, and lots of information was given to try and prove that there was phone hacking. Now, from the outset of this video and every other video that I make regarding phone hacking, I'm not in agreement with phone hacking. I don't think any publication should be phone hacking, planting listening devices, all that kind of thing. Normal methods of reporting, I think, are fine. And, normal, interviewing people, speaking to people, I think is fine. That's normal journalistic practice. But what's the word I'm looking for? The kind of underhand tactics, those are not what I'm in for at all. I don't think those people should be bugged. I don't think phone lines should be tapped or, as it was, in the phone hacking case, it was all the voicemails, all that kind of thing is not something that I am happy with, that I think should have happened. But it did, and lots of people had kind of private settlements many years ago. For the royals, it was said that Her late Majesty kind of did a bit of a deal with the press, that they would settle their claims and get an apology after everything else had been dealt with, and it wouldn't go public. And I think the thinking and the logic behind that was that any kind of stories that the press had bugged and reported on would be kind of corroborated in a very public apology. Basically, it would be saying that all of those stories were true. And I think quite wisely, the Queen and senior figures in the royal family and in the royal household felt that it was better, especially after that much passage of time, when people's memories had kind of forgotten a lot of those stories, that it would be better to get that private apology, private compensation, and then you wouldn't have to talk or drag all of those stories or kind of, admit that those stories were true in the public domain in today's world. So basically, let sleeping dogs lie, get the apology, get the compensation, jobs are good. Which I think was actually quite good, sound positioning, if you like. Now, William chose to settle the royal way, and he did settle privately. He got an undisclosed amount of money, but it is said to have been quite substantial, and an apology. Harry could have done exactly the same thing. In fact, I do believe that William and the Queen actually said that Harry was able to settle in this manner, but he chose not to. Then obviously they stepped back and they left, and then Harry decided that he wanted to go very public and go against, I suppose, the wishes of his late grandmother, because she was still alive at the time when he started this legal process. So we've got a tale of two brothers. One handled it one way, Harry handling it another. I think what's most important to Harry is the apology and the admittance of guilt, really, and of wrongdoing. But obviously, he has to prove that this actually happened. And I don't know, the evidence that we saw previously, I don't know whether or not it is enough to actually get a ruling in his favour when it eventually goes to trial. There is certainly lots of information, people coming forward that Harry's team had kind of unearthed that they were trying to bring in. Now, the Leveson Inquiry dealt at the time with all of this, and they did a deal with the legal side, did a deal with the newspapers, saying that if they disclosed certain information, that it would never become public. And those kind of testimonials, Harry wants made public and then used in this case. Not just Harry, the other celebrities involved as well. So it seems that this information has been kept, if you like, sealed under the Leveson Inquiry agreement with the newspapers. Like I said, to protect the integrity. So, you know, if you make a deal, it's to kind of protect that legal integrity, which I do think is important. Now, Harry's team seem to think in a letter that Harry and the other celebrities kind of penned collectively, if you like, they kind of think that this information will have to come out anyway. Well, we'll see in due course and in due legal process how that goes. So, as I said at the start, this is a tale of two halves of reporting. The Mail Online, of course, are claiming that there was a victory for them in the fact that Harry and the others cannot bring the information that they wanted to the table to be used at trial, whereas Harry and Harry's supporters are claiming that it's a victory, that it's actually going through to trial in the first place. What we don't know is how much of a difference that information that has now been excluded would have actually made in securing that evidence, because let's not forget, as I said before, that Harry and co will need evidence, not just, circumstantial evidence. It will have to be evidence. So it is a tale of two halves. It is a blow to Harry's side that they cannot at the moment use that information, but it is also a blow to the associated newspapers because it's actually going to trial, and there is a chance that they could lose and have to make a public apology and have to pay damages to Harry and co. The thing, as I've said before, that is a little bit tricky and a little bit different is that going public kind of corroborates these stories. It kind of says, and it's going to drag, if it goes to trial, it's going to drag even more out of the woodwork, and all of these stories that perhaps we thought might be true, might not be true, that we were a little bit, kind of ambiguous about, and that had slipped to the very, very back of our minds, is going to come out as probably being true. So, at what expense is Harry doing this for? Like I say, I think he's doing it for his own satisfaction, his own ego. He's been on a massive drive, score settling. That's what he's been doing. Harry has been on a score settling mission for the past 3 or 4 years, and I don't think he's showing any signs of stopping, but it's not doing him any favours, in the public perception of him. I was at a meal over the weekend talking with friends, and Harry and Meghan came up, and basically, this is just a very cross selection. A friendship group is full of different political leanings and different opinions, and everyone pretty much said that they just want Harry and Meghan to get on with it, to sort of get over the past, stop looking in the past, and actually just move forward. We're just getting a little bit bored of it now, aren't we? It's just a little bit, we're just getting all very blasé about it. boring, move on, do something new. And the problem with Harry and Meghan is they're not very creative people. And you think, oh, well, that's not true because, Meghan was an actress, that's very creative. Well, it is an art form in the fact that you get to act and be creative with the character, but you are reading lines typically written by other people. So it's not very creative in that sense. When you think what Harry and Meghan have created as part of Spotify, Netflix, it's all been pretty much, looking back to the past. For example, Harry's Invictus Games was basically a copy of the Warrior Games. Meghan's book, The Bench, was basically a bit of a rip-off of another book that was about a bench. Copying the scenarios of the foundations. They are not very creative, and I think that is why Spotify dropped them like a sack of hot potatoes. Because after 2 years, they realised that they would have to be the ones that put the input in to get anything or, anything substantial out. It was a huge effort to get Harry and Meghan to create and do anything. And that's because they are not creative. Harry himself is not creative, and Meghan is not particularly creative either. She is with words and language and kind of, speech writing and, blog posts, but she hasn't gone back to that. They've been looking to the past instead of looking to go forward. And that is what came up in a private discussion that I had with friends over the weekend. Now, the one thing I should also do, because maybe you haven't actually seen it yet, is actually read Harry's letter. So it doesn't actually say that it is Harry's letter, but it has been released by Hamlins, who of course represent Harry. So I do think that Harry is the driving force behind all of this. He is the one kind of using his legal team to kind of usher all the other celebrities together, basically teaming up, ganging up. He is the kind of puppet master, if you like, I think, in all of this. And I think the others have just gone along with it for the ride. And I think this letter kind of almost shows that. So dated the 10th of November, and it's a press statement, judgment in relation to various claimants versus associated newspapers. Statement on behalf of Baroness Doreen Lawrence of Clarendon OBE, Sir Elton John, David Furnish, Elizabeth Hurley, Prince Harry, Sadie Frost and Simon Hughes. So very careful to put his name further down the list so that it doesn't look like he's leading, but he actually is. So we are delighted with today's decision, which allows our claims over serious criminal activity and gross breaches of privacy by the Mail titles to proceed to trial. The High Court has dismissed without difficulty the attempt by associated newspapers to throw these cases out. Indeed, the judge found that each of our claims had a real prospect of showing there was concealment of unlawful acts by the Mail titles, and that this could not have been discovered until recently. Our claims can now proceed to trial. Well, we've spoken about that. As we have maintained since the outset, we bring our claim over the deplorable and illegal activities which took place over many years. Well, again, claims at this moment, not proven, including private investigators being hired to place secretly listening devices inside our cars and homes. I think that should probably read secret listening devices, not secretly. Inside our cars and homes. The tapping of our phone calls, corrupt payments to police for inside information, and the illegal accessing of our medical information from hospitals and financial information from banks. So these are the things that they're going to have hard proof of to get a conviction at trial, a civil conviction, if you like. We intend to uncover the truth at trial and hold those responsible at associated newspapers fully accountable. The judge also found ledgers showing secret payments by the Mail on Sunday to private investigators, which had been provided to our lawyers and could not be used at this stage. So basically, trying to influence the judges by putting out the information in the public domain, but not being able to use it at trial. So a little bit sneaky there. So at this stage can't be used without the consent of the newspapers or the government, which is unlikely, as I said before, because that would bring these kind of bargains, this information bargains that were done, into disrepute. They claim that this only delays the inevitable, since they will have to be produced in the course of the claim. Well, we don't know if that is true or not. However, if the Mail and the Mail on Sunday have nothing to hide, so directly speaking out to them, and they genuinely believe our allegations are unfounded as they appear to claim, they should provide us with the ledgers voluntarily now and let the claims proceed to trial as quickly as possible. I think I sense the calling of bluff involved here. So basically they're saying, well, we're going to find it anyway, but if you want to give it to us now, because actually we really do need it now, then, you know, please do that. So I see a little bit of bluff calling. Baroness, Dorian, all the others, Prince Harry and Sadie Frost Prince Harry and Frady Soft are represented by Hamlins. The others are represented by Gunnar Cook. That is the bit I'm talking about. So this statement is put out by Hamlins, not Gunnar Cook, which kind of shows me that Prince Harry is kind of the one that's leading this. And of course, David Sherborne, his little paw prints all over everything, and all the other legal teams are named. I mean, David Sherborne must be making an absolute fortune out of all of this. I think if there's one winner in all of this, it's David Sherborne's coffers. He'll be the one rolling around in a Scrooge McDuck style money bin after basically fleecing Harry. My goodness, he saw Harry coming, didn't he? Anyway, I just thought I would read that very interesting statement, just in case you haven't already. Like I say, we don't know how this trial is going to go. Bottom line is, I don't think it's a victory. This is a victory for anybody at the moment. It's that kind of legal do-si-doing, it's that legal dancing that's going on at the moment. And we are not going to see the conclusion until kind of spring of next year. So let me know your thoughts and comments in the comment section below. Thank you for watching this video. If you've enjoyed it, please give it a big old thumbs up. Don't forget to share on social media, and of course do hit the bell so that you know whenever I upload a new video. From me, mwah, to you all, and goodbye.